Well, good evening.
Good evening.
Good evening.
My name is Anita Earls, and I'm running statewide for the North Carolina Supreme Court. And this is nothing short of amazing. I will be very brief, but I do want to tell you a little bit about myself and why I'm running. So I have been a civil rights attorney for the past 30 years. I became an attorney because I grew up in a mixed race family. My father's black and my mother's white. And when they met and fell in love in Missouri, it was illegal for them to be married. So they moved out to Washington State, and I grew up in Seattle. And it wasn't until I was 7 that the U.S. Supreme Court decided the case that invalidated those laws across the country. But that experience and many others taught me how important it is that we have lawyers who are willing to work towards that guarantee that is etched in stone over the U.S. Supreme Court, the guarantee of equal justice under the law. So I was very fortunate to be the first one in my family to go to college, to go to law school, and to come to North Carolina and really follow in the footsteps of Julius Chambers, the civil rights attorney who pioneered so many landmark cases in employment discrimination, school desegregation, voting rights. And for the first 10 years, I traveled across the state of North Carolina representing plaintiffs in voting rights and civil rights cases. I then had the opportunity to go to the Justice Department. I was a political appointee in the Clinton administration. I was the Deputy Assistant Attorney General in the Civil Rights Division. And there I got to see how civil rights enforcement happens across the country. But I came back to North Carolina because I wanted to be closer to the communities that I was partnering with. And it was really when I was working at the UNC Center for Civil Rights, again with Julius Chambers, that I faced the biggest challenge to this belief that we can use the law to get us closer to equal justice. That happened 12 years ago. I was in my office. I got a call from my dad. He was very distraught. A neighbor had come over with a newspaper article, and the subject of the article was that a black man had been killed. That black man was my brother. So I went home and I worked with the authorities to try to get a prosecution, and over several months, and I remember very vividly, in fact, standing at my brother's funeral. He served in the Army for 10 years. So after they shot off the rifles at his funeral, I stood in front of my family, much as I'm standing in front of you now, and I said, I will work to get justice for my family. But I was not able to. And I was given 2 reasons for that. The first reason was this happened in a rural area, and murder prosecutions are really expensive. The second reason I was given was that in the prosecutor's view, no jury in that county would convict a white person of killing a black man. So I came back to North Carolina and tried to figure out how can I stand up in front of communities and say, yes, we can work for justice, when I could not get justice for my own family. And that was sort of a go big or go home moment, and I decided that if I couldn't get justice for my family, I could work to get justice for others. And so I founded the Southern Coalition for Social Justice to work across the South, and that's where we've been doing the voting rights and redistricting litigation. We've had cases in Texas and Florida and Virginia and Tennessee, but also plenty in North Carolina. And what is happening right now in North Carolina, and has been happening over the past 6 or 7 years, is a 2-pronged strategy to make sure that the voices of progressive, African American, and low-income voters are not heard in the state. Strategy number 1 is to suppress the vote. So that monster vote suppression law, which the Fourth Circuit said discriminated against African Americans with surgical precision, was something that only happened because the Voting Rights Act was declared unconstitutional. And let me just tell you one word about one of the plaintiffs in that case. Rosanelle Eaton was a plaintiff in that case who herself had to take a literacy test in order to register to vote, and who throughout her life, she's now in her late 80s, early 90s, throughout her life, she's worked to get people registered so that their voices would be heard in communities across North Carolina. And you may remember that President Obama wrote about her in an op-ed piece, and I visited with her recently, and her daughter told me the story of President Obama, the White House, calling her and saying, President Obama would like to come meet with you. She's on the phone saying, well, you know, that's all very nice, but we have a primary coming up. I have to register voters. Fortunately, the White White House was persistent. He called back. Ultimately, she did visit with him after the primary. But the point is that across the state, there are people like Rosanelle Eaton who have been tirelessly working at the local level to try to make democracy in North Carolina work. So the second strategy, you may know that after the court found that voter ID law unconstitutional, the General Assembly said, oh, okay, let's just amend the state constitution. So there is now a constitutional amendment on the ballot in November to allow the General Assembly to put in place a voter ID requirement. The second part of the strategy is redistricting. And you should know that we sued again, in state court, challenging the legislative and congressional districts the day they first became legal in 2011. And the state courts found that these districts are racially gerrymandered, but decided they were justified. And it took us federal court litigation and 6 years to finally get the U.S. Supreme Court, with regard to the legislative districts, deciding 9-0 without briefing and oral argument, just summarily affirming that those districts were racially gerrymandered. And that's why, for the first time now in 2018, we have new legislative districts in North Carolina, and we have contested races in all 170 districts. I think that's good for our democracy. With the congressional districts, we're still litigating. I had to leave the cases so that I could run for office, but when the legislature had to redraw the congressional districts, they openly said one of their criteria was partisan advantage. They said, we will only consider maps that give us 10 Republican districts and 3 Democratic districts. So a 3-judge court, not surprisingly, found that to be a partisan gerrymander under both a 14th Amendment equal protection theory and a First Amendment theory. The U.S. Supreme Court remanded after it decided the Wisconsin case. That's why we don't yet have new congressional districts for 2018. But we're hopeful. Let me slide into why state courts matter. Think about Pennsylvania, right? Pennsylvania's Supreme Court found their districts unconstitutional under their state constitution. They are not waiting for the U.S. Supreme Court. They have the protection they need. I can point to other areas that we care about. Iowa's Supreme Court found that restrictions on a woman's right to access to reproductive health services violated their state constitution. They don't have to worry about what this U.S. Supreme Court might do. I believe that we are in a moment where the kinds of clients that I've been representing for 30 years are not going to have a favorable audience in our U.S. Supreme Court. And that's why I decided it was so important to stand for the North Carolina Supreme Court. I just want to finish with a word about why your support makes such a huge difference. I'm in a 3-way race. You may know the legislature passed 5 laws trying to impact the outcome of this particular Supreme Court seat. One of them was declared unconstitutional, but the other 4 are still in effect. I won't go through all of the games that they're playing, but we have a situation where the General Assembly wants to take over our courts. They have openly said that because they write the laws, they should be the ones who choose who interprets the laws, which, if you understand anything about checks and balances, that would sound a little strange. I'm a first-time candidate. When I said I wanted to run, the political consultant said, you got to raise $1.5 million. I said, well, okay. Let's do it. Our Supreme Court race in 2016 was the most expensive in the country. $5 million in outside money came into the state. The opposition has already started. The outside groups, we know that money will be spent. And what you are helping me to do is to at least get the word out there about my candidacy, about who I am, why I'm running, why this race matters. This event tonight will help me get closer. I think I might get to 1 million. I will get on TV in some of the 6 media markets. But also I've run a very grassroots campaign. Over 70% of my donors give $100 or less. And it's been really important to me to have a field component. Judicial candidates usually don't. I believe that if I can encourage people to vote in 2018 and to know why their vote matters, they'll vote in 2020. So I am enormously grateful to all of you for being here tonight, and I want to leave you with what I tell people everywhere I go. and that is never give up, never lose hope, and never doubt that you can make a difference, because our lives depend on it. Thank you.
So I'm in the very unfortunate position of having to go after that. So, I have like 5 pages of notes that mentally I was like,